a landlord can only bring a tenancy to an end if the fixed term has come to an end or if the tenant is in breach of their tenancy agreement. A notice given by the landlord is the start of a legal process. It doesn't have to mean you'll lose your home. Section 8 and Section 21 notices can only be used in relation to an assured tenancy or assured short-hold tenancy, AST. A Section 8 notice must state the reason for eviction. A Section 21 notice, sometimes called a no-fault eviction, does not need to state a reason for eviction, but can only be used for an AST. The COVID-19 pandemic has meant that government has introduced emergency legislation to do with tenant evictions. Your eviction notice will tell you all the information you need. After the notice period ends, landlords have to apply for an order for possession from the court in order to continue the eviction proceedings. It's illegal for a landlord to evict you by any other means, such as changing the locks or harassing you to try to persuade you to leave. License agreements have slightly different rules. If you live with your landlord, are a lodger, or live in temporary or emergency accommodation, you'll normally be a licensee. Notice periods for a licensee should be reasonable, apart from in cases such as antisocial behaviour. Landlords don't always need a court order to evict you from a licence. Notice periods for licences have not been affected by COVID. If you're not sure what type of licence or tenancy you have, check out our Bitesize rights video on tenancies and licences. If you're a tenant, these are the steps your landlord must go through to evict you. Landlords serve a notice to bring the tenancy agreement to an end. You don't automatically have to leave the property at the end of the notice period. Your tenancy rights and rent payments continue until you leave or are evicted. When the notice period ends, your landlord can apply for a possession order if you're still in the property. Once a possession order has been given, only county court bailiffs can evict you, and they must give you 2 weeks prior notice of the eviction date. If you've received a notice to start eviction proceedings, talk to your landlord first. You can also check if the eviction notice is valid. You may be able to resolve the situation if you can agree a repayment plan for rent arrears or accept support to address antisocial behaviour such as substance misuse. Ask an advisor or the council to check if your deposit is protected in an authorised scheme, if you were given all the right tenancy documents before the notice was served, if you have an outstanding written complaint or repair and have received a notice after this was made. Check out the links at the end of the video for more information on finding out if your eviction is valid. Remember, even if the proceedings go to court, you have the right to appeal at every stage. If you want to dispute the eviction and have received the court papers, file a defence as soon as possible and before the possession hearing. If you do not agree with the outcome of the hearing, you can ask the judge for permission to appeal. If an order for possession is made in court, you can still make an application to suspend the bailiff appointment. At P3, we can support you to keep your home or find somewhere else to live. We can try and resolve the situation by mediating between you and your landlord, connect you with support to address rent arrears, substance misuse, or anything which may be a barrier to you staying in your home. Support you to find another suitable property. We'll always advise you to speak to your landlord and try to resolve things first. The end of a Section 21 notice does not mean you automatically have to move out. If you have nowhere else to stay, ask the council for help before leaving. Moving in with friends or family temporarily, or leaving your home while you still have a right to be there can affect what help you can get. Under new emergency legislation, there may be an extra step called a review hearing date. For more information, contact the on-duty advisor, whose details will be included within the paper served by the court. There's a lot of free resources you can access for further advice. Check your notice for where to find free independent legal advice. Call the Civil Legal Advice National Helpline 0345 345 4345. Contact your local advice agency such as the Citizens Advice or Shelter. Ask for a duty advisor at court who can advise and represent you. Click the links below the video for more information. Remember, it's best to seek advice as early as you can and before you go to court.